Good afternoon, everyone. Yes, yesterday in our session, we captured the discussion on IBC in the say. Sorry. Yeah. So in our yesterday session, we have discussed in detail on how the IBC integrates with the labor laws. In today's session, we would be extending a discussion to that of the Companies Act 2013 vis-a-vis the IBC. So as at the time of inception of IBC, let's go a step back to understand the relevance of this topic. See, in 2016, when IBC has come into picture, it was only the corporate insolvency and the corporate liquidations which were notified under the IBC. And as you are aware, subsequently, the part 3 has been partly notified only to the extent of personal guarantors to the corporate debtor, which is a personal insolvency. Otherwise, the rest of the procedures, like that of the corporate insolvency resolution process, liquidation process, voluntary liquidation process, or even the pre-packaged insolvency resolution process, all of these are pertaining to corporates only, which is the corporate persons, which is nothing but a company incorporated under the Companies Act 2013, 1956, 1913, or any other Companies Act which was there in force in India at the time of incorporation of that company. So for all companies, IBC has been the one-stop shop to see if they, in order for them to close or shut down the company in whatever be the route, right? So company per se, as I mean, since centuries, you could say that corporate law has been in force. The jurisprudence behind the corporate law was there for quite some time in the world, and particularly in India, 1956 Act has been the act. The Companies Act 1956 has been the act with tremendous amount of adoptions from the UK Companies Act or from the US Companies Act, some portions of it. And prior to that, we had the Companies Act 1913. So, since centuries, we have Companies Act in place, and the corporates have been bound by a particular law. Now, when you bring in IBC and say that, notwithstanding anything contained in any other law which is inconsistent with IBC, IBC shall prevail. Does that mean IBC shall prevail over the Companies Act? The answer is yes and no. The reason is, it might be yes if there is any provision which is inconsistent with that of IBC, but majorly it cannot go no. It cannot be inconsistent because companies are bound by the law of Companies Act 2013, and the IRP or the RP is responsible to ensure compliance of all the laws, including that of the Companies Act 2013. So if we get if someone believes that as RPs we need not do any compliances under the Companies Act 2013, then that would be wrong. In fact, I have seen certain RPs receiving notices from the ROC for non-compliances under the Companies Act in terms of non-filing of GNL2s. So compliances under the Companies Act become extremely crucial for a company which is undergoing CIRP, and I'm talking that only from the RP's point of view. You see, of course, there can be certain compliances which are not possible to be pulled off during the CIRP because of the situation of the company. For instance, let's say all the directors resign and no new director is willing to take up directorship because of the insolvency status of the company. No, this is 100% possible. But as RPs, we should always keep showing that efforts in place to see what all compliances we can do, how best efforts we are putting in to see to it that the compliances are being done is something which the RP has to look into. Like see, in majority of the cases, insufficient information or non-availability of information might also be a reason. For instance, we file a form called Form DPT3, which is a return of deposit, and if as RP the financials are not yet been provided to the RP, then how can RP ensure that this kind of compliances are in place, right? However, once the financials and everything are being handed over to the RP has to endeavor to see to it that all those forms are filed with the MCA through GNL2 route, right? So that is something which is extremely important. So Companies Act per se should not be diluted merely because the company is undergoing CARP, right? Nevertheless, there are obviously certain relaxations which have been there and certain operation of law which comes into picture with respect to the Companies Act and its implications on and the implications of CARP for a corporate data. So let's quickly get into these nuances and understand this much better. Now, let's see how both those acts or the statutes are placed and how the interface has been built. In under both the statutes, the adjudicating authority is the NCLT for any disputes, right? Even under the Companies Act. In fact, it was under the Companies Act that the NCLT and NCLATs have been established, right? The rules of NCLT are also laid down under the Companies Act, right? Not under the IBC. And it is under the IBC that they have notified these sections, or they rather identified NCLT as the adjudicating authority, while NCLT has been established under the Companies Act. So typically, NCLT's primary jurisdiction is ideally Companies Act. So practically, you see a lot of IBC matters overshadowing the Companies Act matters in the NCLT. But as a matter of law, NCLTs are established under the Companies Act and their principal or primary jurisdictions are under the Companies Act 2013. Right? Yeah. Now, next is with respect to the Companies Act. I mean, in fact, the IBC per se has amended the Companies Act 2013, particularly the 11th schedule, wherein one of the grounds for winding up being inability to pay debts has been omitted from the Companies Act, and in place of that, an entire new code, which is the Insolvency and Bankruptcy Code 2016, has come into picture. Right? So this omission of inability to pay debts as one of the grounds of winding up is one of the key elements of the amendments brought in by the IBC to the Companies Act 2013. Right? I think 238 we have already seen. In this, only one point we need to note is that though Section 238 provides, though the Companies Act 2013 provides for the powers of the board of directors of the company, it cannot withstand the IBC because there is an inconsistency between the Companies Act and IBC to the extent of the powers exercised by the board of directors. So where the board is exercising the power under the Companies Act, the same powers are being suspended during the CARP as per the IBC and are vested with the RP. Meaning, this inconsistency of provision cannot give any preference to the Companies Act interpretation. So the directors cannot come and say, Companies Act is what binds us, so I have every power to do this. No. Because there is an inconsistency between the Companies Act and IBC in terms of the powers of the directors, the IBC will prevail. Therefore, the powers of the directors being suspended and are now being exercised by the RP shall prevail over the powers granted to the directors under the Companies Act 2013. And in fact, whatever powers are granted to the directors under Companies Act 2013 shall continue to be, or shall rather be vested upon the resolution professional who is appointed under the IBC. So that is all about the non-obstant reference of Section 238. And in terms of compliances, all that which, unless there is anything specific, everything which is to be complied under the Companies Act will automatically apply to the company undergoing CARP, like that of maintaining the registers or even conducting the statutory audit. And if there is a secretarial audit applicable, then conducting a secretarial audit, cost audit, internal audit based on the applicability. If CSR is applicable, that can also be applicable during CARP also. So whatever things are applicable during, under the Companies Act, the same shall automatically be applicable even under IBC, right? So now let's move on to the aspect of what's going to happen to certain important organs under the corporate law. See, under the Companies Act, generally, whenever I teach corporate law, one thing I usually would like to stress upon is the meaning, definition, and identification of the term company, right? So, the term company has evolved from a practice of two or more people going together for a picnic, right? So company is actually a couple of people going together and doing something together, right, as a picnic. But then it slowly evolved into people coming together to do businesses, right? And then it has come up, the jurisprudence has evolved to come out with the principle of separate legal identity, right to sue, right to be sued, right? Having completely distinct identity from that of its shareholders, directors, and other stakeholders, right? So that exactly is the point where I'd like to focus on. That a company is different from its shareholders, from its directors, as well as from its officers or the KMPs or any other stakeholders. Now, what does that mean? It means the act of a company cannot be equated to the act of the directors unless there is a situation for lifting of a corporate wheel. Similarly, the shareholders and the officers. So, the situation becomes interesting to see when the company enters the CARP. No, till now it's fine that okay, the company is different and all that. We do a different meetings, and the company's meetings are nothing but the meetings of the shareholders, while the directors' meetings are also there. So there are two different set of decision making bodies, etc. All of that is fine during the process. I mean, in a situation where the company is not in CARP. But once the company is under CARP, things will change. So let's look into that. Coming to the board of directors, what happens? Their powers will stand suspended, right? And see, most importantly, it is only their powers which get suspended, not the office. So once the company is into CARP, doesn't mean the director has resigned or the director's position is gone. The director will still continue to be a director. It is just that their powers are suspended. So now we need to read it quite clearly. Now, see, when the powers are suspended, does that mean the duties are also suspended? No. So, a duty of a director to sign the financials, a duty of the director to have fiduciary responsibility towards the company, right? And the duty of the director to ensure that all the responsibilities provided to the director are being done in the best interest of the company. All of it has to be adequately provided for, right? So that's one thing which we need to realize, that a director under during CARP, the director will still have a role to play, right? It's just that they don't have any powers, but their position as a director should not be substituted, right? Now, um, and then, of course, a different angle altogether. Generally, directors are privy to the board meeting discussions, and board meetings are considered as one of the most confidential documentation because we can't find it anywhere. It's only maintained by the company. Because if there are any special resolutions passed, AGM notices, etc., are usually matter of public record. But board meetings and the deliberations during the board meeting, the minutes recorded thereof are all highly confidential documentation which cannot be made available to the general public. So, such is the situation in which the directors were operating. And then suddenly you come into CARP, whereby the directors are now invited as mere observers in the meetings of the committee of creditors. I'm sorry. So directors are only invited as um, participants and as observers in the meetings of the committee of creditors without any voting rights. So such directors, they will be typically, as per the code, they are entitled to receive the notices of the COC meetings. At the same time, even the copy of resolution plans should be made available to the directors whosoever are present. Now, see, so the role of directors to be present in a COC meeting is that they are supposed to be present to give inputs to the committee of creditors regarding the company, right? No, they are not there to litigate. So, in majority of the cases, I see that the directors, whoever are participating in the COC meetings, they come up with some pre notion, right? So, the pre notion which they come up with is that the directors have a I mean they want to strongly oppose anything and everything being discussed, right? At times that is usual for the directors to do, right? So in such cases the directors tend to inform that we will bring in our lawyer as my representative in the meeting, right? So that they can talk on our behalf. Such requests keep coming to the committee of creditors. Now, see, if the committee allow such lawyers to be part of the meetings? Answer is absolutely yes. Committee can allow anybody to join. There is no bar on that as long as some confidentiality kind of undertakings and etc. are taken. But more importantly, is it necessary for the company to accept such a request from the director? That is exactly what we need to look into, right? So that is where I'd like to comment that particularly in the case of directors, particularly in the case of directors, we should not allow any advocates to represent them in the COC meetings. For the simple reason that the presence of the legal counsel of the director has no importance to the COC meeting, right? So the director was expected to be participating in the COC meeting in their capacity as a director of the company. Now, in their capacity as a director of the company, it is only the director who can provide the inputs, not some of their represent authorized parties. For instance, in the meetings of board of directors, can you expect anyone representing other than the director to come and appear on their behalf? The answer is no. I mean, you may still say alternate directors is a possibility, but alternate directors is only when this director is not in India. So there is no such concept of representation of a directors to be present in a board of directors meeting. Then how can we allow such representation in a COC meeting, right? So if I have to repeat, under the Companies Act, when I conduct a board of directors meeting, it is that only the respective directors shall be present, right? Their representatives, there is no such thing called representative of a particular director in a directors meeting. So I'm talking about a board meeting which is completely outside the IBC purview under the Companies Act. But where there is a wherever there is a uh, uh, COC meeting where the law mandates for the directors to be invited to the meeting, the intention is for the directors to be present themselves, not to be present through their representatives, right? So that understanding has to be absolutely clear, right? So that's about it. And then, of course, all the board's powers are will be accessed by the RP, and board will not be in a position to transact any transaction, and the entire committee structures will, for the time being, go dormant. Right. So that's what exactly happens with the board of directors and the members of the committee. As we move forward, what will be the position of members? Right. That is the shareholders of the company. Now, see, members' rights completely survive. There will not, the IBC does not hamper with the rights of the members, but at the same time, the decisions typically for which we used to approach the shareholders might no longer be required during the CARP, particularly with respect to raising of funds, etc., since the same shall be the point of concern of the committee of creditors, right? So that's again an important area. So one interesting explanation provided on the Companies Act gives a clear indication of how the lawmakers want to look at facilitating compliances for a resolution plan which is approved under the IBC. Now, Section 30, subsection 2, clause E, the explanation thereof provides that for any action, right? For any action which needs the approval of the shareholders under the Companies Act 2013, such approval is deemed to have been provided, right? So such approval is deemed to have been obtained from the shareholders. Okay. So such approval is deemed to have been provided by the shareholders as long as that action is for the purpose of implementation of the resolution plan. For instance, as part of the plan, the share capital of the company shall be increased. Now, typically under Companies Act 2013, the share capital can be increased only upon the approval of respective shareholders by way of special resolution, or sorry, by way of ordinary resolution. Now, whether the share capital increase has taken place or not, right? Whether the share capital increase has taken place or not is something for the members to decide during the process which is outside the CIRP. But when we come into CIRP, it is typically the COC which will decide on such issues of any additional issuance of shares which we want to do during the CIRP, additional securities which we are issuing during the CIRP, which never happened during the process. But under Section 28 of IBC, such power is being vested with the COC, right? Now, under Section 30, subsection 2, as I was explaining, so if at all as part of the implementation of the resolution plan, if the share capital has to be increased, then the law assumes the approval of the shareholders under Section 30, subsection 2, clause expression thereof, only because it is deemed of the approval of the NCLT to approve the resolution plan is a deemed approval of the shareholders for all the corporate actions required for implementing the resolution plan, right? So that is how one has to read this particular provision. Now, with respect to the next set of thing in terms of officers, sorry, before we move on to the KMPs, the members, right? So if at all there is any transfer of shares which is happening during the process, even the Section 28, which is the powers of the COC, it provides that there has to be prior approval of the COC sought for the sake of allowing the transfer of shares, right? And if it is the case of a listed company, then all the SEBI regulations will apply, and the shareholders should be provided with whatever is the information which is needed by them during the process, right? So this is all about what's going to happen to the shareholders. Now let's look into the role of the KMPs. Now this is interesting because the company might have a company secretary or a chartered accountant, right? I mean the CFO. So if in such cases where the company has CS and company secretaries, they'll have to mandatorily cooperate with the RP because they will be reporting to the RP. As per the IBC, they are reportable. They report to the IRP and they shall give all access to all records and registers or any accounts to the IRP. So the role of the KMPs become more vital during the CIRP. In fact, KMPs are expected to make sure that they are cooperating and providing all the required information to the RP from time to time, right? So that is something which is needed. And now let me give you an example. If at all so if at all during the process, let me give an example. We are handling one process of a listed entity, and all the compliances have to be met even during the CIRP, right? So in such case, there we have a company secretary who is doing all the filings with the stock exchange. But then what we did is that, see, company secretary is doing filing not on his personal behalf, right? The filing is being done on behalf of the company. So since the filing is done on behalf of the company secretary ideally should not have the authority to do that. But as per the law, he is the compliance officer as per SEBI LODR, right? So therefore, the RP, we've put in an SOP to mean that whatever disclosures are being filed, even under the whatever compliances are there, that will be first put before the uh, uh, RP. The RP will approve, and only then the 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 company secretary is filing the same with the stock exchanges. So that's exactly what I was trying to summarize, is that the signatures of the CS or CFO will now be flowing under the RP's authority, right? So the RP will be the one who will be deciding to allow them or not to allow them from signing something, right? So that's one thing. And then typically, whosoever is a statutory auditor before the CIRP, they shall continue during the process as well, unless the committee decides to change the auditor under section 28 of the code, right? uh, next next is in terms of right. So next let us move forward. Yeah, so this is what happens to the board of directors members as well as the KMPs of the company. As we move forward, the first 30 days, once we take up as an RP, what compliances trigger under the Companies Act? Let us have a look at it. First and foremost, we'll have to file Form INC 28 with the ROC, right? So INC 28 with the ROC will be the first step to be initiated. The timeline will be 30 days from the date the NCLT passed an order admitting the company into CIRP. So within 30 days from the CRP commencement date technically, or which is nothing but the NCLT admission order, that will be the deadline for filing of Form INC 28, right? Now with this filing in the master data, the company's status will change from active to under CIRP, right? So this is what INC 28 does. Similar compliance applies at the time the resolution plan is approved, so that the status of under CARP will be removed and active will be added. Similarly, the status, I mean, once the liquidation order is passed, if at all the liquidation order is passed, again we will have to file INC 28, so that the status of the company will change from under CIRP to under liquidation. So that is how INC 28 is relevant. Next is in terms of the public announcement, right? So under the public announcement, what we do is we'll file, of course, as we know, we will immediately do a public announcement in Form A and publish with the um, detailings. Now, here there are some cases where we can intimate this. I mean, we are supposed to intimate this with the stock exchanges, and if needed, if as a predominant and as a precaution, you can also intimate the same to the ROC for filing of any claims. Then subsequently, also an intimation to other sectoral regulators and other regulators with who may have some bearing or some claims to be filed with us. We can communicate the same to them as well. Third is particularly in terms of the records. So some standard records like copies of minute books, right, common seal, share records, or any other documents. Again, typically these are the ones which are needed to be handed over back to the resolution professional. I mean, back to the resolution applicant. So that's about it. And point number 4, yeah, the signatory hygiene, meaning we'll have to ensure that our DSC, right, our KYC, DSC, etc., are being properly filed and maintained with the MCA portal. Because you cannot expect like on same day all will happen, so you'll have to be prepared like even before you think about filings, all your DSCs should be in place. You should have associated your DSC with the MCA, right? So such kind of compliances also should have been done by then, right? So that is something which we need to ensure. Next is in terms of the compliance calendar.
Sir,
So
one point.
yeah,
May I raise? Sir, just you mentioned that filing of AOC for MGT7. Sir,
Now I'm coming to that. Uh,
these are not possible, sir.
no, no, I've not yet started on it, sir. I just finished till the DSC thing. Now I'm going to explain on the AOC for MGT7. Now, after that we can certainly discuss. So I
Okay.
think your concern, I clearly get it. Why it is not possible on couple of reasons. One, during the CIRP, if at all the financials are already approved, are in place, I mean, let's say we get the financials audited and closed, the major challenge for us would be to conduct the annual general meetings, right? And if we are not in a position to conduct the annual general meeting, then this particular form AOC 4 and MGT 7, the very typical threshold for that itself is the date of AGM. So when we cannot select the date of AGM, that itself will defeat the whole purpose of filing these forms with the RSC. Correct, sir? Or do you have anything additional to say in terms of these?
AGM is also not possible. AGM is not possible. That's why AOC for MGT7 not possible.
Yeah, yeah. But sir, if I can tell you this, that there are some cases where even AGMs are done, and these forms or these financials have been
No,
adopted to
sir.
the file.
Even if
Uh,
AGM is called,
uh,
no decision can be taken in the AGM.
it
because
is only adoption of
because
finance.
AGM, whatever decisions are taken, are to be taken by the AGM,
Hmm.
that is deemed that to be taken, even if they do not do that, because COC overrides. COC has all power. Therefore,
Correct.
that AGM, in AGM they cannot take any decision. They cannot approve anything. So that when a meeting, members cannot take any decision, that is not a meeting. Therefore, this is inconsistent with IBC. Therefore, IBC overrides this particularly this provision of the Companies Act.
Sir, I partly agree with you, but then again, it is only an adoption of financials which is being done by the shareholders. They are not approving or rejecting the financials. They are only supposed to adopt the financials. If they adopt, they adopt. If they don't adopt, also it's fine. But ultimately,
That's
as
why that's why I'm telling. If they don't adopt, that does not matter. That's why that particular provision holding AGM under Companies Act, that is not inconsistent with IBC.
okay, sir. But filing of form AOC 4 and MGT 7 are mandatory, sir. We should not take a stand that we cannot file. That's why they
No,
allow us
sir.
to file
Sir,
it.
how can you file 11? That's why it should be filed. I have been doing in many cases. I have been doing the same thing.
Correct.
That is AOC for MGT 7 not possible. I have been filing it through a GNL2 only.
That's what is.
Because yeah, no doubt whatever you are telling that
No, no, we are filed. We are
statutory
supposed to file the general 2 only, sir. That's what I'm saying.
statutory that audit that is required. Maintaining that is not inconsistent. Maintaining record not inconsistent.
Correct.
Making financial statement not inconsistent. But filing of the financial statement through AOC 4 or annual return, it is not possible. Therefore, the financial statements are to be filed through GNL2. But unfortunately, what ROC is doing, they are not updating the filing status on their
They
website
won't,
as
sir. They
per
won't.
GNL2.
Correct. Correct.
Hmm.
No, that is not technically possible, sir, because GNL2s are general forms. So ROC does not tie up those forms with any master data. Whereas AOC 4 and MGT 7 are specific forms which are tied with the master data.
Yes,
So
that
we
is
cannot
a true
expect
process. That
master
is
data.
that changes that, but that should be done through the back end or anything. The MCA should take care of that.
Hmm.
But MCA or ROC, they cannot compel the RP to
Hmm.
file MGT 7 or AOC 4, because
Of course.
that meeting itself is inconsistent. Meeting
I
cannot be called.
I don't think
Who
so.
will call, sir? Who will call the meeting? AGM is called by the board.
RP is in the powers of the board.
AGM,
RP can call.
if you go through the Companies Act, who has the power to call the AGM?
The board
Board of
directors.
directors. RP is not supposed to call the AGM. Board of
This is
Directors power, and Board of Directors is suspended. Board of Directors cannot call. Therefore, AGM cannot be called.
No, no, sir. I think you are taking a very rigid view on this. Considering, let's say, the company is a listed entity and you need to do the compliances under LODR. LODR does not, relax any compliance of AGM as such. Even though we may file for a waiver at a
Sir,
later
I
stage.
am not taking, sir, I am not, I am just interpreting the law.
No, 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 no. I understand.
In LODR, if those provisions are there, then the people who are at the helm of the affairs, who are making laws, they should understand this and they should
It is agreed. Yes,
reconcile all things.
correct, correct.
In
That is,
LODR, ROC says you file a annual return. You file a AOC 4. It is not possible. I am not telling that I will not do as RP, I will not go for statutory audit. Yes, that will be done. I
mm.
will take care of the records, registers, that will be maintained. But calling meeting, who will call the meeting? RP does not. RP is not supposed to call. RP doesn't. In the section 20 or 25 duties of RP or IRP, that is
Huh.
not there. That is not the duty of the RP to call the meetings. It is the duty of the it is the power of the board of directors to call AGM. And board of directors, when board of directors is suspended, there cannot be any AGM.
So, exactly.
I am sorry, I am taking your time. Please go.
No, 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 no. You're not taking my time, sir. It's interesting actually because, as you said, it is the power of the board to call for an AGM, but at the same time, the power of the board is now exercised by the RP. So
No,
technically,
power of the board. No, no, sir. I'm sorry. Power of the board is not exercised. Nowhere it is to, written that power of the board to be.
no,
Power
it is,
of the board is not.
no, it is in the
Duty,
law. IBC
power
says
of
clearly
the duty and
RP
power
powers.
of the duty, sir. Sir,
So
let me
I'm
finish.
hearing out
Duty
also,
and
so you
power.
can't speak on. Tell me, tell me, sir.
Duty and power of the RP that is defined. Board has there may be some a lot of similarities, but yeah, that RP does not assume the power of board of directors.
No, no, sir. It is written. It is written in the law. Okay, I'm not reading. I'm not telling something on my own. It
Okay,
is
sir.
written
Then
in.
let us go to section 20.
Yeah. Section 17, if you open, sir, section 17, subsection 1,
Okay,
clause
sir.
B.
Okay, sir. I may be wrong. Let
Yeah,
me.
no, that's okay, sir. So it only says that the powers of the board of directors of the corporate debtor shall stand suspended and be exercised by the interim resolution professional. That is what is 17(1)(b).
Okay, sir. Let me go through it. Let me go through
Yes,
it.
yes, yes, absolutely, sir. Please take it.
Okay, okay. When the power of a board of director, as the case may be, shall stand suspended and exercised by the inter.
And be exercised by the IRP. And now going to your section, and if you see same 17, sir, 17(2) subclause E, it says the IRP be responsible for complying with the requirements under any law for the time being in force on behalf of
No,
the CD.
that is all
Yeah.
right. That is all right. Which is in
Other point,
which is consistent. That is,
yeah.
and I have also another view that if I call for what purpose a meeting is called? Meeting is called to
Yes.
discuss an issue and take a decision. That is a meeting. Meeting is not to sit together to discuss an issue and take a decision. Whereas if I call a general meeting, that meeting
Yeah.
of
Sure. Hmm.
members cannot take any decision because whatever decision they are supposed to take, that
Hmm.
is deemed to be taken.
So that is not given anywhere in the law, sir. It's only for implementation it is deemed to be taken. But under the CIRP,
Can the members, if the members come together and can they take a decision to change the RP? They cannot do
that
that.
is not. No, no, exactly, sir. There are certain.
Can they decide? You tell me. What decision can they take? Can they
No,
take a decision to create some asset? Can they take a decision to sell some asset? Nothing. No decision can be taken by them. It is
Correct.
the power of the COC. COC ultimately RP that now you are telling. Okay, let us. I take that your point that RP has assumed the power of the board of directors.
Board
Then
directors. Correct.
under whose authority RP exercises? RP exercises his power and duties under the supervision of COC.
Yes.
So when, but earlier what happens? Board of director was exercising his power and duties under the supervision of the that is general meetings members. Ultimately,
Correct.
members they do that. Now the same board of directors is under COC. Therefore,
Correct.
in general meeting, members cannot take any decision. They cannot, when they cannot take any decision, how can we call it a meeting at all?
Agreed, sir. So can you hear me now, sir?
Yes, sir.
So now, sir, I totally agree with the practicality of what you're trying to say. Now, there are two ways of looking at it, sir. One is the legality, one is the practicality. One is, as per law, does the shareholders' power subside? Is there anything written? Nothing is written to that effect. Does it say shareholders cannot convene an AGM? Not written. Does it say shareholders cannot be part of the AGM? It is not written anywhere. What is written is the powers of the board is suspended. It will be exercised by the RP.
Sir,
Now,
exactly that I am telling.
let me
What
finish.
you are telling not written, that
Let
is
me
inconsistent. That I am telling.
let me
When
finish,
it
sir.
is inconsistent, it should be taken as overrated.
Jaina, sir, you have to be patient enough to listen. I have heard you for 5 minutes. You're
Yes,
not
sir.
able
Yes, sir.
to.
You continue. I understand you.
No, no. Let me finish. Let me just finish. Just give me. No, you can't. You just have to listen also, no, sir, not just speak. I'm only trying to say that. No, see, in a forum like this, we can't give a single thought process, no, sir. Whatever is in the law has to be given. Now, how they interpret
I
it is
am
up.
not giving anything. I am just telling. You
No,
are
sir,
telling I am rigid. Okay.
can you please be patient enough to listen? Just for a minute,
You
I'll
are
explain.
not listening. Why should I listen?
Sir, I've listened to you for 5 minutes. I'm speaking for 30 seconds and you're not able to bear it. Anyways, what I was trying to say is your point is absolutely right. That if we propose something to the shareholders, can the shareholders take a decision? You're absolutely right that, for example, like let's say shareholders say that, okay, we want an EGM to be requisitioned. Now, can the RP requisition an EGM for the shareholders? Yes or no? Yes, it's an interesting question to answer. Then comes, let's say shareholders want that, okay, this particular asset has to be sold. Can they do it? No. Can the shareholders change the RP? The answer is no. You're absolutely right on all these fronts because all these are addressed under section 28 of the COC, of the IBC, saying that COC will have a decision making in terms of transfer of shares, in terms of acquisition of assets, transfer of assets, or anything to that case. It is the COC which will be taking the ultimate decision. So even if the EGM shareholders do something under the Companies Act and they come forward, ultimate decision has to be with the committee of creditors as per the IBC. And over there, you're absolutely right that if there is inconsistency between the IBC and the Companies Act, the IBC will prevail. So considering this as an inconsistency, if a shareholder takes any decision which is inconsistent with the IBC, 100% IBC will prevail. I am totally with you on that. But only area where I'm trying to explain my thought process, you may differ on that. It's up to you. It's up to me for me to explain my thought process is that in a process like IBC, where the section clearly provides for the powers of the board to be exercised by the resolution professional, and the nothing in the law. You're right that lawmakers should have given the clarity. I'm absolutely with you on that. And but in the absence of lawmakers coming forward with any clarity on how this Companies Act provisions has to be interpreted vis-a-vis the IBC, particularly in terms of conducting AGM and adopting the financials, we cannot take an interpretation that, in my view, that AGM is inconsistent with the IBC, because in AGM what we do is only adoption of financials. Now that adoption of financials is left open to the shareholders whether they adopt it or not. Now, firstly, whether the quorum is met or not, And then nextly, if the quorum is met, whether the financials are being adopted by the shareholders or not. And if the shareholders don't adopt the financials, absolutely fine. We will report the same in the AOC 4 and MGT 7 that financials have not been adopted. Now, my only thought process is that if the law is silent, things cannot be assumed. If the law intends that there is no need for an AGM for approval of financials or adoption of financial statements of the company, then the law should be specific enough to explain that if a company is undergoing CIRP, the financial statements need not be adopted by the shareholders of the company. But the law doesn't say so. So if the Companies Act doesn't say so, if the IBC doesn't say so, is it right on the part of the RP to interpret that, okay, I don't need to do this particular step, I will just go ahead and submit the financial statements as is without filling the forms AOC 4 or MGT 7, is something which might not be looked into in the good spirits, is my thought process. So the point is we should put our efforts to convene an AGM rather, and if the shareholders don't turn up, then to adjourn the meeting as per the Companies Act. If someone turns up, there is a quorum. If they don't turn up, there is no quorum. So therefore, we can have sufficient records to prove that we have tried convening the AGM, but none of the shareholders have come. Now, looking at it from the point of view of the shareholders, obviously, see, practically, as I was saying, you are 200% correct that this makes absolutely no sense. That why would a shareholder who knows whose value is deteriorated, who has absolutely no return from the company, why would they come forward and even cooperate with the RP to even adopt the financials? And on the first instance, as you rightly said, who are they to approve or disapprove something? But since it is, again, it's a jurisprudence evolved from centuries, right? The Companies Act thing. Now, to set it aside, there has to be a sufficient enough law. As you rightly said, that is one point I totally agree that the lawmakers should think whether it is practically possible or not to do an AGM. If it is not possible, it should be clearly laid down under the Companies Act or under the IBC that RP need not convene any annual general meetings or any shareholder meetings. All approvals are deemed to have been given, should have been clearly laid down under the IBC. But unfortunately, under section 30, subsection 2, clause E, where we talk about deemed approval of shareholders, that only addresses for all implementation plans, only with respect to actions taken for implementation of the resolution plan. It is only in that direction where we have the deemed approval of the shareholders. But in terms of other aspects of the Companies Act, the law is silent. I'm just saying the law is silent. I'm not saying you are right or wrong. The law is silent. When the law is silent, at least I don't want to take interpretations which will have a hamperance on the role of the RP. That's the only limited submission I have. But otherwise, I'm completely with you. It makes absolutely no sense to have an AGM when they don't have a power to take decision making.
Okay.
Yes, sir. So, yes.
It is completely ridiculous that members they have not appointed the RP.
Correct.
How can they adopt the financial statement in which the RP fee is decided by somebody else?
RP fee. Okay.
RPP, they have not decided RPP.
Correct.
So only as per your argument, only for adoption of financial statement we should come the meeting. Only for
Yes.
it. But for adopting the financial statement, all the expenditures that during this CIRP period, all the expenditures that have been incurred, that is approved by somebody else, COC.
Correct.
And that the members have to accept. That
It's the
means
same as that.
they are at gunpoint. They have to adopt. They adopt the financial statement. No, this is completely ridiculous. How can they adopt a financial statement for transactions which they are either against or they have not approved at all. They do not have any opinion on that. How can they?
It's same
So
the company.
adopting a financial statement by the members, it is also not possible. If at all I do that, that is only at gunpoint, and no other decision can be taken by them. As per your
Mm.
argument, only adoption of financial statements.
Mm.
You come and adopt. So how can do that? So therefore, this meeting is completely ridiculous. That meeting is not possible. That is not a meeting. So
Okay.
I do not know, but I disagree. Let us live with this.
But under Companies Act also is the same situation, sir. So under Companies Act also, the board of directors appoint a lot of employees. Their salaries are also not decided by the
Yes,
shareholders. But
no, no. I am a company secretary also. I understand.
yeah, I also
Okay.
consider, sir. I also understand what you're
Yeah,
trying to
I
say.
also understand company act. Thing is
Yeah.
that suppose some financial statements are
Mm,
there, and
mm,
those financial statements, members they do not agree. On that, what happens?
mm.
Director they explain these
Correct.
members.
Correct.
So, but here
So
I
there
have
was
to. I do not have to explain you. Approved by COC. That's all. No explanation.
your
So
audio is lost. Okay. Can you repeat, sir? You're saying we need not explain to the shareholders, right? Yeah. I can hear you now, sir. Okay. It's again, no, no, again lost. So you both your audio and video are lost.
sir, please continue. Continue, sir. Continue. You continue.
I can hear you now, sir. No, I
Yes,
get
sir.
your
You
point.
can. Continue.
It's
Continue, sir. I am wasting your time, sir.
yes, yes, sir. Thank you. But I 100% agree on the point that it is definitely inconsistent with convening the AGM is inconsistent. So that clarification should have been provided is my only point. That the law should have given a clear clarity because like say you may have a strong view on this, I may have a strong view on this, but it is not right for every RP to start taking views. That's where it leads to a confusion on whether or not to do it. So ideally, the lawmaker should have given absolute clarity on how the Companies Act pans out during the CARP. Otherwise, these kind of situations will 100% hamper. And particularly, I see that this listed company CARPs, stock exchanges keep on writing. Why is this not done? They keep on imposing penalties. They keep on imposing non-compliance notices under LODR, which is again inconsistent. Ideally speaking, they shouldn't do all that. Even though at a later stage they are waiving off all the penalties at an application made by the RA, but they keep on troubling the RP saying that this is not filed, that is not filed. Lawmakers also should give the clarity
No,
to
no.
ROC.
You are telling I don't interpret the law. Then if I do not interpret in this way, then who are you to interpret in in your own way?
No, that's what I'm
Because
trying to.
because if as there is no clarity, I am doing in some manner and you are doing in some manner.
Absolutely,
Your
absolutely.
manner, I do not agree with you. You
Correct.
cannot tell me that RPH are not free to interpret the law in their own way.
No, no,
Okay,
no.
because
So,
you are also interpreting the law in your own way. Because
yeah, yeah,
as you told that duties that duties is not suspended,
correct,
power is suspended.
correct,
That is also interpretation. No, only duties means no duty can be performed with the equivalent power. If power is
correct,
suspended, duties they will do their duty only to the extent which is fiduciary in nature, which is essential.
correct, correct. That's what I said.
For example, calling AGM, that is their power or
Hmm,
their duty, whatever may be.
hmm.
Power duty, that's a very thin difference. Okay.
I-
But thing is that if they do not have that power, how
Hmm,
can do that all duties? Only that's why court interpreted. When
hmm.
it went to court interpreted
Correct, correct.
that signing of financial statement is your duty. You do this.
Yes,
That does
yes,
not mean that all the duties that they have to perform because they don't have power. How can they do duty? That is my interpretation. So
agree, sir.
yeah, my point is that if something is inconsistent, what I am telling, I am not telling I am a RP and I have to carry out my duties. If it is possible, I will do that.
Correct.
But when it is not possible, That's why I am interpreting in my way. There is no clarity. At the end of the day, adjudicating authorities, they will decide.
Correct.
That is my limited point, sir. Thank you.
Yes, yes. No, I'm with you on this, sir. I'm rather telling the lawmakers should have given the clarity. That's all I'm saying. They should rather understand our problem, because not in all cases, I was also able to do, sir. In some cases, it's impossible for us to do an AGM. We know it, right? In fact, audit also becomes impossible because of lack of information. We fight behind the NCLT and all. So lawmakers should understand that and come out with some clarification, is what I'm trying to say, so that we all do things consistently, or in a correct way. So
Sir,
NCLT,
you see one more point. 4 board meetings should be there.
yeah,
As you told, RP has taken over the board. That
correct,
means board meeting, RP will carry out the board meeting. That board
correct,
meeting must be reported. Is it
correct.
possible? You are telling the board of directors is suspended, but
Hmm,
RP is taking over the board of directors. That
hmm,
means 4 board meetings are to be done.
correct.
So how can board meeting be done? Board of
No, sir.
directors suspend. How can be done? But if you file AOC for MGT7, the board meetings are to be shown. These are
Yes,
mandatory fields.
yes,
Without these mandatory fields, MGT7 cannot be filed.
correct.
So how can I file MGT7, sir?
No, you're absolutely right, sir. That's what I'm trying to say. These loopholes should be addressed, is what I'm trying to say. That's all. I'm not saying there are no loopholes. I'm only saying that they should clear cut provide it in the law, that can be relaxed. This is not applicable during CARP. This is not. That's a simple effort,
So
no, sir.
they have given the clarification that wherever it is inconsistent,
Yes,
it
yes.
overrides.
But
So
that's
my
what.
point is that it is inconsistent. It is not possible. That's why it overrides.
Understood, sir. But again, what I'm trying to say is, since only their powers are suspended, I can still call them for a meeting and I can still discuss about the business of the company. Now we are only assuming. Let us assume the company has no business. What if the company has business? Today I'm doing a so no, I'm serious about this. Like, there's a listed entity where we are adopting the financials, and as per LODR, we are doing a board of directors meeting to adopt the financials of that quarter and to
Suspended.
exchanges.
The directors who are suspended, I
Yes,
will call and take a meeting. Is
yeah,
it possible?
it is
They
possible.
are suspended.
Their
But
powers are suspended, not the duties. So they are still liable. When I call for a meeting with the board, they are still
that's
supposed
why
to.
I'm calling. If you call a meeting,
Yeah.
if they do care, they do not have power to take a decision. Is it a meeting?
No, no. They don't have powers under the Companies Act. It doesn't mean they can't approve what RP is proposing. No, sir. It's just simple. Let's say there's a financials for the year ended 31st March where they were the directors prior to the insolvency commencement, sir. So ideally, they have to do a board meeting to approve those financials. Without a board, how can they approve the financials and sign it and give it to us? Whereas the insolvency has started after. So wherever the powers are there is again, as you rightly said, thin line of difference between power and a duty. Duty to sign financials, and financials they just cannot sign. It has to be by way of a meeting of the board of directors. Who can call a meeting? Only the board. Board's powers are suspended, so the RP is exercising the powers. So RP will call the board. Now again, you're right. Your interpretation is one way. My interpretation is exactly on the opposite. But then I'm only saying that there has to be some clarifications for these kind of procedural issues. Of course, 238 is there. Wherever there's inconsistency, IBC will prevail. But IBC also doesn't necessarily say anything in this effect. No, IBC doesn't say no need to have a board meeting. IBC doesn't say no need to file Companies Act forms. Now, if IBC said so, then there's no.
IBC is not about Companies Act.
Ah,
Where
no,
should
no.
IBC say, tell about the things?
Going concern, sir. IBC.
IBC tells wherever it is not consistent, then it overrides.
Okay, sir. In that way, there are a lot of things which will be we can interpret as inconsistent. Yeah. Okay, sir. Thank you, sir, for actually making it more interesting. So yes, as we move forward in terms of the next part is identifying the related parties, right? So yeah, sorry, this compliance calendar. Yeah, this is what we were discussing. So as per the law, the RP is supposed to file all the requisite forms through GNL2. So particularly AOC4, MGT7 are supposed to be filed to GNL2, and 100% it is a matter of fact that when we fill these forms AOC4 and MGT7, it is impossible for us to give the 100% data, because yes, we will not have board meet. We would not have had done the board meetings of the directors during that particular time. Directors are not cooperating, or all the directors have resigned. There is no minimum number of directors. So all these issues will have a practical implication while we are filling these forms AOC4 and MGT7. But it is as per the MCS notification that we as RPs are supposed to file the financial statements and these particular forms AOC4 and MGT7 through GNL2 route. So there are practical nuances involved in ensuring the compliances of these forms. But again, if at all, if there is a possibility for us to make sure that this kind of compliances can be met, then all efforts should be put in place to meet, is my view. And if we are not in a position to do it, we should at least make sure that the financials are duly filed with the ROC by way of GNL2 filing, so that at least the major crux of the financials are in place and they are being produced before the ROC, right? So at least that will establish our bona fides in ensuring compliance under the Companies Act for this particular company. And then as we move forward, other compliances like MSME 1 and DPT 3 are also relevant under the Companies Act. So since again, if nowadays there are certain forms where RPs, DSCs are also being recognized, if these forms recognize it, absolutely better to make sure that the filings are done through the RPs, DSC. But at the same time, if it's not happening, then better it is to file it through GNL2 route. And apart from this, any other compliances which come over to an RP during the entire process, typically that situation will not arise, because it is a case of a company. I mean, it's a case of IBC. So therefore, anything and everything is mapped through the COC. Hence, majority of other decision makings for which we usually file other forms, that those situations never arise. So only it is the case of annual filings or periodical filings which step in. So only in such cases we'll have to ensure the forms are being filed through GNL2 route. Now, another important thing which we need to remember in terms of this compliances is that, particularly at the time the plan is approved and a new investor is stepping in and taking over the corporate debtor, that is a situation where things become more relevant, because I mean, these compliances become more relevant because typically the new the incoming resolution applicants expect that majority of the old compliances should be complete. At least if let's say there are many of the RPs would have already experienced this, that when we step in and take over the process, we see that the company's audit is pending for last 5 years, 6 years, 4 years, 3 years. Typically that was never our responsibility to finish the financials of those particular years. But having said that, if I have to complete the audit of the current period where I am the RP, I'll have to ensure the completion of audit of all the past periods as well. And not just that, even the incoming resolution applicant, the successful resolution applicant, will expect that all these audited financials are being handed over. Right? At least this is my experience from my matters, where majorly the resolution applicants always have an expectation that all the audited financials, even for the past period where RP was not in charge, all of it has to be handed over and the audit has to be complete till date. Right? So compliances play a key role even during the transition of the control from the corporate debtor to a resolution applicant, right? So that transition of control, this handover of compliances, is also an extremely important step. And if the resolution applicants now today understand that, okay, it is the GNL2 filing which has to be done, and then subsequently if they take it forward, then they'll have to take it forward to see to it that relevant non-compliances, if they can do it from their end and complete it as per the law, right? There is as per the regulations, it also stipulates for certain, you can take some relief from the Companies Act to provide certain time period within which any old compliances can be complete. So such kind of compliance issues might happen at the time of handing over control to the resolution applicants. Even such situations have to be adequately addressed. And then moving forward, in terms of related parties, so the definition of related party under the Companies Act and IBC has a slight variation in terms of one particular clause, where under the IBC they also identify companies where there are two or more three or more common directors are in place. So in such cases, it identifies that party also as a related party, while that clause is absent under the Companies Act 2013. But nevertheless, that that mapping of related party might be relevant from the point of view of 29A, so that it's easier for us to screen certain ineligible PRAs. And in addition to that, even at the stage of claim verification, because when we file these forms with the IBBI mandates us to mention whether a party is a related party or not. Even in such situation, this related party disclosures under the disclosures in the financial statements or the registers maintained by the company will come to importance, because we can identify whether a claimant is a related party or not, and accordingly report it with the IBBI in the list of creditors which we file with the IBBI. Right. So that is one part. And in addition to that, in fact, even when we are doing these avoidance transactions, it will be easier for us to identify who are all the related parties. So these are certain things which we can take you help of under the Companies Act 2013. Right. And yes, in terms of compliances, in terms of the financial statements, right? So financial statements, ideally for the period where RP was never in control of the operations, we will be requiring the board to submit the signed financials of the company for that particular period. And for the period where RP is also in control, where the board's powers are suspended, but still they are intact. And as we have discussed, as Sardindu sir has also pointed out, that NCLT has, in couple of matters, has identified that it is a duty of the directors to sign the financial statements. So even during the CIRP, the directors will have a duty to sign the financial statements. Nevertheless, the RP signature will also become important, because in addition to that, it is the RP actually who is in control of the operations or the finances during that particular point in time. So RP's signature will also have to be added to the financial statements, in addition to the signatures of auditors and directors, and if there's a CFO, company secretary, in addition to all the signatures, even the RP signature is ideally to be put in place. Then, as we already discussed on AOC 4 and MGT 7 filings, in my view, the obligation should still survive even if it is during the CIRP. But having said so, definitely, if these form filings are 100% complicated, there is the information is completely, incomplete. So it depends how we can fill it, or we can just file the financial statements with the ROC through GNL2 route, as we do in majority of our cases, because it is highly impossible to fill in all the data whatever is sought in this particular forms. And and then of course, as I said initially, we need to make sure that our DSC is already associated, so that whatever form filings we are doing are being done in accordance with the Companies Act. I mean, in on the MCA, particularly INC 28, GNL2s, etc. There should not be a rejection based on our DSC. So therefore, associating the DSC of the RP becomes important. And yes, as regards AGM, this also I think we have discussed. There is no express exemption provided for companies undergoing IBC. In fact, just to share one of my experiences, that in one of the matters where we were assisting in the compliances, and the COC and the RP decided and informed us to extend the timeline for conducting of the AGM. Now, see, technically speaking, in my view, why all this in terms, I mean, the compliances in terms of AGMs, etc., have not been envisaged in the code nor in the act, is maybe because the law was intended to complete this entire process within 180 days, right? So the idea was never to spill this beyond this period. So therefore, if it is within 180 days, technically, there should not be a situation where these non-compliances might trigger, right? So therefore, maybe that was the point of context by which maybe certain exemptions have not been even addressed. But having said that, the ROC has also considered giving extension because the company is undergoing CIRP. So again, in my personal view, the IBC is silent. Companies Act is also silent. yes, I also partially agree with Sardindu sir that this is inconsistent and therefore IBC will prevail. But then at the same time, if there's a possibility we can do the AGM, the possibility we can get the adoption of financials done, it is safer to do it. And in my view, even if the board of directors is in place, we can still have a meeting to discuss on the company's status and close the meeting. There need not necessarily be a meeting where always we will take decisions. So therefore, we can simply have a meeting for the purposes of meeting the compliances under the Companies Act if there is a possibility. But then I know it is more theoretical than practical. So practically, since it is all a big impossibility for us to achieve it, at least we need to keep this record straight in the COC that this is inconsistent or this is not possible. So therefore, this cannot be done. So that at least the views are adequately captured in the COCs. And tomorrow, if any kind of notice comes from the IBBA, we can at least address this, that this has already been discussed and deliberated, and this was the view which was taken. And yes, coming to the statutory audit, yes, the statutory audit 100% is applicable. We cannot take any exemption on that. The audit will continue. And if the existing auditor resigns for any reason, or if there is no auditor appointed for a long period, we have to take that step in to appoint the auditors under Section 28 of IBC. It is a COC which has the power to appoint auditors. So even appointment of auditors will become, is coming under the ambit of the COC, and the RP should, in line with, in consultation with the auditors, should support the completion of the audit to the auditors, give requisite information to the auditor, taking support from the board of directors whose powers are suspended, and to give all that information which he has to the auditor so that the audit can be completed, right? And then yes, event based filings, of course, in after the plan approval, typically all these things would come in, like that of satisfaction of charges, if the RA wants to change the registered office, or if the obviously the plan proposes for reduction of capital and allotment of new shares, so the form PS3 will step in, and in fact even the change of directors will step in. But all of this is being done as part of the post implementation of the resolution plan, right? So as part of the implementation of the resolution plan, and these are not part of the CARP period, right? In CARP period, typically these event based filings don't trigger, and only event based which we can see is, or the periodical filings would be that of MSME forms and the DPT forms. There is the deposit returns as well as the MSME outstandings which has to be recorded. And then cost records, yes, again, if this maintenance of cost records is applicable to the company, then we have to ensure that the cost records have to be maintained, right? And whatever other registers, ideally, in an ideal scenario, RP should have taken handover of all the copies of board minutes, AGM minutes, all statutory registers. Everything should be kept under the control of the RP, control and custody. And as and when a new resolution applicant is stepping in, the same should be handed over to the resolution applicant. But typically we see that these registers are either not maintained or cannot be traced, right? So in such situations, obviously it is not possible for us to hand over such things to the resolution applicants. But then this becomes crucial. At least we need to make sure that we are discussing this in the COC meetings, writing letters to the directors requesting them to hand over the control of all this documentation, and if not received, then we should approach the NCLT to inform that these documents and records have not yet been made available to the IRP, right? So that again is an important aspect. So yes, I think the 17.2e we have already discussed in terms of responsibility for compliances. Yes, that is where all this steps in. Yes. Now coming to listed corporate debtors. Now, in addition to the Companies Act, for the listed corporate debtors, even in fact, the LODR plays a critical role, because see, on one hand, you see, if the Companies Act or LODR is completely silent on IBC, then yes, there is enough scope for us to go back and see, boss, whether this is in line or not in line, etc. But the Companies Act as well as LODR has partially, they come up with, they partially provide for some clauses here and there addressing a situation if it is in a case of an insolvency. Particularly LODR. In LODR, there are various regulations which provide for a large section of relaxations for the companies undergoing CARP, and also for the companies which have stepped out of CARP by way of approval of the resolution plan. Both of it we can find it in the LODR. So LODR still provides for certain relaxations. Now, if such a document, LODR meaning listing obligations and disclosure requirements regulations of the SEBI, if these regulations do not provide for a relaxation, it ideally means it becomes applicable to the corporate data, right? So typically, what it does is all those regulations in terms of corporate governance norms, that is having minimum directors, that is the board composition or the board committees, etc., all that become exempt during the CARP, right? Now, but one interesting aspect here is nothing of this sort has been provided under the Companies Act, while such clauses are there as part of LODR. So it again becomes interesting to see that under LODR, all of this has been exempt, while the Companies Act still is being, hampering us with those compliances without any written exemption on the companies, right? And then subsequently, since the RP is in place, the LODR also recognizes certain mandatory disclosures to be provided by the RPs during the CIRP, which is the Regulation 30 disclosures, right? So, in terms of constitution of a COC or issuance of EOI, or if there is any plan approval, or there are many multiple things which have been disclosed with the timelines as to what all has to be provided to the stock exchanges. So all of that has to be ensured. The compliance thereof has to be ensured by the RP. And apart from that, even the financial results the quarterly financial results continue to be placed before the stock exchanges on a quarterly basis. And in fact, the trading in the securities of the company also is being continued on the stock exchanges, right? So today, the shareholders are still able to uh, participate in trading of the securities of a company which is undergoing CARP. So now, again, that raises certain questions. Of course, it's a different area to argue that should the lawmakers or should the regulators allow shareholders to trade in shares of a company which is undergoing CARP, because typically in almost 100% of the cases, the entire shareholding of the shareholders will be brought down to 5%, or in some cases may even be completely written off, and compliances to maintain minimum 5% public shareholding will be done through other forms. So is this what is expected in terms of allowing the shareholders to keep trading? Because ultimately the one who is continuing with the company is bound to lose the net lose the value in the shareholding at the end of the process, right? So but still, I think as of now there is no such thing to suspend the trading at all. But once the company is entering liquidation, I could see that the stock exchanges are issuing a suspension of trading notices as and when the RP or as and when the liquidator informs the stock exchange in terms of commencement of liquidation. I could see that the stock exchanges are immediately suspending the trading in such companies. So maybe it is high time for SEBI also to see the status of such trading during CARP. But as of now, the shares are being traded even during CARP, right? And yes, Regulation 30 disclosures we have already discussed. And yeah, plan stage actions. So if at all the plan provides for a delisting, then the disclosure has to be clearly provided for in delisting. The plan may also provide for reclassification of promoters to public shareholders, right? So that may also be possible. And not public in the sense, reclassification of promoters as non-promoters. Now, this is one of the most important clauses to be placed in a resolution plan from the point of view. Of course, it has nothing to do with the implementation or recovery, but from the point of view of compliances with the stock exchange. If tomorrow you want to continue this company as a listed company, then this reclassification part is an important part, because because technically, as per the SEBI LODR, if the plan provides for reclassification, then it is deemed to have been reclassified, right? So if the NCLT approves it, then the plan, the such reclassification is deemed to have been done. So none of the procedure prescribed under that regulation will be applicable. So therefore, if at all we are looking into a plan where the promoters are being, of course, the promoter shareholding will be wiped off, and therefore the plan should ideally address this part on whether the reclassification of promoters, that is of importance, so that subsequently whenever the PRA is the resolution applicant continues the compliances of the company post CARP in their shareholding patterns, they need not provide these details and names of these promoters. Now, this is purely a practical scenario because as per NSE and BSE, once a promoter is disclosed as a promoter, once any person is disclosed as a promoter, their name can be removed from the list of promoters only by way of reclassification. And the only exemption from the process of reclassification is the resolution plan approved by the NCLT. So one liner from in the plan to just simply say that these guys are no more the promoters, or cannot be classified as the promoters of the company, something like that. That will help in ensuring adequate compliances. And in fact, see, even otherwise, maybe we can still convince the stock exchanges, but it will always be easier to have to show a clear-cut clause so that the other person will be in a position to understand that clause to the to the extent which it is meant to be interpreted under the resolution plan. Then and the LODR mandates, I mean, it's a SEBI ICDR mandates that all the new allotments done as part of the resolution plan shall be subjected to a minimum lock-in of 1 year. And because we will be acquiring more shares, more than 25%, right? So therefore, even though the open offer applies, the SEBI Substantial Acquisition of Shares and Takeover Regulations 2012 exempts such open offers to be made, right? So these are certain consequential exemptions being made from time to time by way of amendments to these regulations to facilitate those companies which were undergoing insolvency and which have been resolved during the CARP. Now, this I feel is a welcome move because this gives a certainty or a clarity on what has to be done and what level of measures have to be put in place so that tomorrow, once a company comes out of insolvency, the resolution applicant who is submitting the plan will also have a certainty on what all things can be included, and there it can be a this can give a more certainty and more clarity to all those who are operating without involvement of a lot of legal or compliance support from any third party professionals. So it's easier if something is written in a particular certainty and certain relaxations are offered for companies undergoing CARP so that things become smoother for the resolution professionals to run the process and to ensure that the compliances are in place. Yeah. As we move forward, in terms of, yes, so resolution plan is by and large a single window clearance for a lot of issues under the LODR and of course under the SEBI regulations and also under the Companies Act. For instance, under Regulation 37 of IBBI Insolvency Resolution Process for Corporate Persons Regulations 2015, it provides for various measures which can be provided in a resolution plan, including reduction of shares, consolidation of shares, extinguishment of share capital, right? Issuance of fresh shares, allotting obviously, and changing share capital structure, even corporate restructuring like that of mergers, demergers or amalgamations, and transfer of assets. So the plan can also provide for selling off of one particular asset, which might be an idle asset of the company, some land lying somewhere. The plan can provide that this land will be sold and the proceeds thereof will be also used towards implementing the plan or whatever. Right. So all these clauses, all these measures which are provided under Regulation 37 need some level of compliance structure. Like for instance, extinguishment of share capital ideally cannot take place without NCLT approval. But once the plan is approved by the NCLT, extinguishment is also deemed to have been approved by the NCLT. Coming to issue of fresh shares, ideally it is a private placement because we are issuing shares to pre-identified investors. But then, because of this deemed shareholder approval provision under explanation to section 30 subsection 2, wherein it says any approval of the shareholders is required under the wherever any approval is required under the Companies Act or any other law for implementing the plan actions, that is implementing the actions provided under the resolution plan, then such approval is deemed to have been provided for, right? So we need not take any separate approval from the shareholders or any other body for the purpose of implementing such steps, because the shareholders approval is deemed to have been provided for. And um, one another interesting thing is that under section 30 subsection 2 clause E, this I think we discussed even yesterday, that the resolution professional must examine every plan and must also examine whether the plan is in contravention of any of the provisions of the law. So compliance of all the applicable provisions of the law is also an important criteria for the resolution plan. So therefore, the resolution plan should make sure that adequate these kind of reliefs are also adequately addressed and utilized, so that there is no non-compliance as part of the plan, right? So again, if you see section 30 subsection 2, there is a clear, this explanation provides a clear exemption that for implementing, for taking any actions for implementing the resolution plan, the approval of the shareholders is deemed to have been given. Now, what is the need for them to do that? The need is only because to avoid any uncertainty, so that all those resolution applicants who come forward very clearly know that, okay, I need not depend on any shareholder to approve my decision making for allotment of shares or anything. I will be needing this kind of approval from shareholders is deemed to have been given, right? So such clarity is what has been provided as part of the IBC for any implementation actions under the resolution plan. Now, one another interesting part is in terms of the scheme of arrangement, right? So, Section 230 of the Companies Act 2013 has been carefully adopted under the liquidation process, which is laid out in Regulation 2B of the IBBI Liquidation Process Regulations 2016, whereby it provides for a deadline of 90 days from the insolvency commencement, and rather this timeline is also excluded from the liquidation process time frame. And this is a period where the a scheme of compromise might be proposed, or scheme of arrangement might be proposed for the approval. And the landmark ruling of Shivram Prasad versus Dhanpal by the Honorable NCLAT had set the tone in terms of what basic compliances have to be put in place to get the class-wise cram down of this particular not crossways approvals of this particular classwise approvals of this particular scheme of arrangement, right? So this is one area where Companies Act and liquidation directly hit each other, but again an harmonious interpretation has been evolved from time to time, and more importantly from the Shivram Prasad matter. And also in 2021, the Supreme Court in the matter of Arun Kumar Jagatramka versus Jindal Steel and Power has also identified, or rather clarified, that one who does not meet a 29A will not be in a position to submit a scheme for a company undergoing liquidation, right? So even for submission of a scheme of arrangement, it is imperative for the one who is proposing the scheme to make sure that they are meeting the 29A criteria, or rather they are not meeting the ineligibility set out under 29A. And of course, this is already provided for in the proviso for Regulation 2B, and the same has been upheld with the Supreme Court as well. And is there a possibility for getting such a scheme during the CARP? The answer is no, because the scheme during the CARP is nothing but the resolution plan. But even if I look at it from the point of view that the promoter wants to propose for a scheme of compromise, they can also participate as promoters as resolution applicants if they don't meet any ineligibility, neither in terms of the financial ineligibility nor in terms of 29A ineligibility, they can 100% be part of the PRAs. But if they have an ineligibility under 29A C or H, and if there's an MSME, even then they can be participating, because 29A C and H are exempted if it is if the company is a MSME. So that is something which is also in place. So therefore, a scheme proposal during CARP is something which cannot be proposed as such in the same sense as what we do it under liquidation. Nevertheless, if the resolution applicant, like not a promoter, some resolution applicant wants to propose a scheme of arrangement under section 230 to 232 in terms of either merger, demerger, or something like that, that is something which is possible. They can do it, they can integrate it, and this is in line with regulation 37 of CARP regulations as well. The resolution applicant can certainly propose for a scheme and make the scheme as part of the resolution plan, so that the same will be put forth before the NCLT, and the NCLT, being a single window, can approve the resolution plan along with the scheme, so that even the merger or demerger, etc., have also been approved as part of the resolution plan, right? So that's something which is possible, and it 100% saves a lot of time if that is what is being intended by the RP, intended by the RA. Now, um, in terms of eligibility screening under Section 29A ineligibility part, there are certain things which will come into picture. That is, number one, the disqualified directors. So, Section 29A E disqualifies all direct, I mean, so it makes the direct disqualified directors ineligible from submitting a resolution plan. Now, who are these disqualified directors? How do we know it? That is something which we can find out from the MCA. And if whenever we search for a director's name using the DIN, we will clearly know what's the status of disqualification of a particular director, at least the formal disqualifications. The same can be taken note of, and accordingly, if that is being found, then even and then such director should not be allowed to participate as part of the such person cannot be allowed to be a resolution applicant. And then yes, the definition of connected person, which relates to related parties, etc., obviously that is where even the Companies Act knowledge can help. In terms of the due diligence part, right, where we are looking for certain compliance issues, or even for understanding where all we have the shares, where all we have the subsidiaries and all, that can also be helpful in if we have sufficient knowledge on the Companies Act part, because that helps us in analyzing what level of associate companies we have or subsidiaries we have, right? Or in fact, even we will be, the RPs will be in a better position to have a clear idea of the group shareholding, which can subsequently be presented to the COC and the resolution applicants to take a call on the corporate data, right? And if there is any conviction for an offence, including amounting to imprisonment, that can also be one area where there is a ineligibility for submission of a resolution plan by the resolution applicant. So if there is a undischarged insolvent, being the status of a personal insolvent, an insolvent person under the personal insolvency laws, or any offences with imprisonment of more than 3 years, I mean, for offences punishable with more than 2 years, the same, they are also being considered as disqualified. So therefore, any offences committed by as part of the schedule provided in the Companies Act, that can 100% be one of the possibilities for disqualifying them. But of course, only if that is being leading to convicting such person by the court of law. So these are certain areas where 29, I mean, the Companies Act knowledge will come to help. And yeah, in terms of avoidance transactions vis-a-vis the Companies Act 2013, right? So in avoidance transactions, we know that for related parties we have a 2 year look back, and of course now recent amendments are in place. So basis whatever are the amended periods, that is something which would apply even here, right? So now there are some parallel provisions under the Companies Act for these things, like wherever in winding up there's a fraudulent conduct of business, right? So then those who are connected with such company will be held liable. Similarly, under 447, which defines fraud, right? So in fact, if the IBC does not provide for any definition of fraud, it is only the Companies Act under 447 which provides for the definition of fraud, right? So that is also being provided under the Companies Act, and then survival after the plan. Now, see, Tata Bhushan Steel Limited is a classic case regarding that. Where they have been arguing on how so these avoidance transactions survive even after the approval of the resolution plan, because see, the law has quietly made it clear that once a plan is approved, the RP need not wait for the RP. We should not ideally wait for avoidance applications to be disposed, because avoidance applications involve detailed trial and it is a time-taking matter. So therefore, time will be tied up if we are linking avoidance transactions with resolution plan approvals, and hence the law mandates the RPs to make sure that they are not waiting for the avoidance transactions to be disposed. They should very well go and file their applications for approval of the resolution plans, and it's the NCLT also cannot wait for disposing the avoidance transaction. NCLT has to mandatorily, NCLT should give them liberty to continue litigating those avoidance transactions, and parallelly not to delay in approval of a resolution plan, right? So yeah, this is all about it. And then now, with respect to the 32A, now this immunity from criminal actions, now this is another interesting aspect wherein we need to differentiate the company from that of its old promoters, right? For instance, let's say there was a fraud which was surfaced, and agencies like ED, the enforcement department, or the CBI have been investigating into the case. And if they start coming up, if they realize that certain properties of the corporate debtor are proceeds of crime, right? So they may end up categorize. I mean, they may end up creating charges on those assets, or meaning attaching those assets as per their proceedings, and then doing the rest of it before the respective special courts. Right now, this is something which can uh, discourage successful interested, discourage certain interested parties from participating in the corporate insolvency resolution process as prospect resolution applicants, right? So to avoid it, I think 32A has been introduced to provide a clarity that all, right, all kind of actions, civil, criminal, etc., against a corporate debtor, should ideally be set free, right? Any attachment of assets of the corporate debtor should be released. No action should be taken for any past offences or offences being done during the CARP. The properties of the corporate debtor nor the corporate debtor itself should be put to trouble. All those who are involved individually in such wrongdoing can still be investigated, and any action can be taken against them as per the law. But whatever are the assets which are lying in the name of the corporate debtor, to the extent of those assets, no action can be taken against those assets. No prosecution shall continue. No attachment shall continue. All attachments shall release against such properties. And then, as I said, no new, neither existing litigation can continue, nor any new litigation should continue against the against the company or the PRA, because of Section 32A. So Section 32A is technically a very strongly worded section providing for a good immunity to the resolution applicants. Right now, uh, what was the one of the, in the case of Bhushan Power, this was tested quite vehemently, right? Wherein it, in Bhushan Power, what happened was, there has been good amount of money paid to the creditors, subject to an understanding that that will be refunded if any order is passed, against them, right? And the major bone of contention by the ED was more on the fact that these attachments are already in place. But then that section 32A was being discussed, and uh, you know uh, the role of the COC after the plan approval has also been identified, and ultimately, the resolution plan which was done, which was approved earlier, was restored, and the order which was earlier JSW's plan, which was rejected, has then been recalled, and then the plan was approved by the Honorable Supreme Court, and thereby, providing some certainty to the resolution applicant. But nevertheless, even now there are certain petitions which are pending, which to be dealt with Supreme Court to address this question of ED versus IBC, right? Yeah. As we move forward, in terms of post approval implementation, yes, there are certain task lists which we have under the Companies Act. Very quickly, the INC 28, which we already discussed, which is for after approval of a resolution plan, then the existing board will be cleared, and the board has to be reconstituted. Now, this also becomes applicable. So, filing of Form DR12 for the incoming directors is there, and also for the deemed resignation of the outgoing directors. Then all capital actions like that of infusion of equity share capital, allotment, amendment of constitutional documents or capital clauses, updating all the registration share certificates and all will also be important. And if considering now all are dematerialized, even corporate actions with the NSDL CDSL become widely relevant. Charge satisfactions become relevant because all the charges will be released by the secured creditors upon payment by the resolution applicant. So the charge satisfaction also will become relevant. And next is in terms of changes, like if there is any change of name or change of registered office, or if there's a new auditor coming in, or new KMPs are being appointed, or the necessary compliances has to be taken care of, right? And all the compliances, whatever are there, will ideally be whatever have been done so far will ideally be handed over to the resolution applicant. But right, see, these
Sir,
none
one
of
point,
this,
one point here.
yeah,
Charges are to be satisfied by
no, no, sir.
filing the CG4.
Yeah, correct. What I was saying is none of these are by the RP. This will be done subsequently.
No, that I'm telling, that I'm
Hmm.
that is to be done by the successful resolution
Yes,
applicant.
yes, yes. Now you can take it up, sir. Yes, sir.
My point is that it is to be done by filing CG4 form.
Yes, sir. Yes, sir.
No, sir. What my point is that
Hmm.
uh, the CG4 form should not be required,
Okay,
because it is the charges are being satisfied by the operation of law. When the
okay,
resolution plan is passed,
correct.
then CG4, the all the charges,
Uh-huh.
they are satisfied by operation of law. So CG, because why I am saying in my
Yes, sir.
case, there are more than 100 charges are there.
Okay,
For satisfying more than 100 charges, I have to, and there are 33 creditors.
okay.
Actually, there were 39 creditors. Out
My
of
God,
39 creditors, 6 creditors, they did not submit their claim at all.
my God.
So these 6 creditors who did not give their claim, if I tell them, please affix your DSC form, DSC on CG4
They
form,
will
they
never.
will not do that. Huh?
Yes,
Again, all the 100, more than 100 charges that is to be satisfied by the 33 creditors. So that's why I am telling it is impracticable, because the
Uh-huh.
successful resolution applicant, if he goes to these creditors, many creditors may not, even after taking money, they taking their part of fund from of the part from the resolution plan, they may
Mm-hmm.
not do that. And there are
Correct.
some creditors, they have not received data. They
Mm-hmm.
will never do that. So the successful resolution applicant, he will suffer.
Makes sense, sir. I think I
Ah,
totally agree with you. Because at the most, what will happen is, even if there might be a modification, let's say the plan provides for the creditors to continue at a renegotiated terms, even then, I think the existing charge should satisfy and a new charge should be allowed to be created. I think I agree with your point on this, sir. This
yes,
kind
this is
of
my simple point is that this is by operation of law, these charges are being satisfied
but
as per
how do
the
you handle
approved
it?
resolution plan. Then
Uh,
why should I file CG form? I am requesting the ROC through
mm,
GNL2.
to
Sir, please
cancel that,
satisfy, but they are not doing that.
they're not. They won't do that, sir. That is a
They
problem.
won't do that. So, so
Maybe
in that case, it will be very difficult for me, because if I go to NCLT also, NCLT will not listen to that. NCLT,
correct, correct. NNC will not understand this difficulty also. They will simply
uh,
do the complaints. But this is impossible for us to achieve, sir. You're right. But what do you think can be done, sir? In this case, if NCLT is not clarifying, then it will be very difficult for you to. I mean, because tomorrow, anytime they take a new loan, these charges will keep on reflecting in the charge register.
yes, the new the corporate debtor under the control of the SRA, they
Mm.
are unable to do business now,
My God, it's such a pity
because they
because
are six creditors.
oh God,
Yeah, out of see who had not submitted their
the
claim,
thing. Mm.
they could not submit. Now I told them your claim is your total your outstanding is extinguished. Now
Mm.
will they give will they give their approval for filing
No,
this AG4?
no,
They
no,
will not
impossible.
give.
They should at least allow the RPs to RPs DSC to allow such kind of satisfaction.
No,
Something like
no. CAG for filing CAG for their consent is required.
yeah, you're right, you're right. I'm just saying at least such kind of thing should have been introduced to address these kind of situations. Today, now they are unnecessarily logged, no sir. After paying everybody, even they're not able to do business also because of a procedural issue. I don't know how this.
NCLT is not understanding. ROC is not doing. ROC is telling you do through CAG 4 firm only.
ROC will not do anything, sir. That is for sure. They, though, you know how they operate. For them, it's just Companies Act is what is there for them. Nothing else survives for them. But what any solution, sir, so far for this?
Sir, though I am out of the company now, I am the member of the monitoring committee, and the
Mm,
SRA is putting pressure on me. They are telling we are not able to do business.
mm. But this is such a tricky thing, sir. If NCLT doesn't give a direction, but did you try knocking NCLT's door, sir, on this?
No, I till now I have not knocked the door of NCLT, but ROC is refusing. Simply ROC is refusing. But NCLT, okay, under section 60 subsection 5, we will go to NCLT. But now filing application against the creditors who are not part of this resolution plan,
Mm-hmm.
it is not possible.
No, I'm rather thinking if we can file it against the ROC with a direction to the ROC to give a
It is
solution.
only through read, sir. It is only through read.
Writ.
Read
Mm,
application.
okay, okay, okay. Understood, sir. So that way, that will give a direction. Some writ directions can be given for the.
Only redirection can be given to ROC. Only that way it is what I understand. But I have not consulted with any senior advocate, or but that is my understanding.
Okay, so I think makes sense, sir. Because if that direction is there, then they will give you a solution how to do it.
Yes, yes.
If direction is not there, they won't give you. That is the problem with ROC. Interesting, sir. Very interesting. Okay, sir. Yeah. Yes, quickly moving forward, in terms of sir, the president set forward in Ghanshyam Mishra and also in embassy property matters. Now, what was what is clear so far is that there is a clean slate provided to all the resolution applicants, meaning that even if there were any past non-compliances, past ROC prosecutions against the company, they should ideally not be uh, continuing against the new resolution applicant, and all that which is all any actions taken under the Companies Act 2013 prior to the commencement of CARP will stand extinguished, and the NCLT approval order will be good enough to address all that situation, right? So therefore we have to ensure that what all reliefs and concessions we are drafting with adequate care, right? So generally, we see that resolution applicants come forward with numerous number of reliefs and concessions at times, which may be relevant, and few clauses which are not relevant. But I think it is always prudent to take some care in ensuring that we are drafting the reliefs and concessions which are simpler, easier to understand, and NCLTs may consider approving. So the specific waivers, right? So that is something which can help us. But in general, NCLTs are not granting random waivers. Wherever it is, they say that the respective department may consider, but generally NCLTs are not coming up with much of waivers other than those waivers under the Companies Act. So as regards compliance requirements under the Companies Act or LODR, to some extent NCLTs are granting, but otherwise NCLTs are not favoring any grant of exemptions as such, right? And in terms of any non-compliances which were there on earlier front, there is always a need for us to ensure that these kind of backlog filings are taken care of. But again, it is practically, seems very unlikely that the resolution applicant will take such a responsibility, but they usually will push that responsibility on the RP to see to it that any compliances which are pending are being taken care of, right? So that is something which we have to be ready to support and close in the interest of resolution of the company. And then in terms of the corporate exits, we have various options like corporate insolvency resolution process, which we have dealt with so far, right? Then if at all we are closing, like after the corporate insolvency resolution process, we want to exit, completely close the company, then we have an option of liquidation under the IBC, a voluntary liquidation also under IBC, winding up under Companies Act, strike off under Companies Act, and we can also propose for an early dissolution under IBC. Now, as regards early dissolution, we have now an exemption from, we have now amendment to the CARP regulations, whereby even during the CARP, the COC may consider the situation of the company or the assets position of the company and dissolve. The COC may resolve for direct dissolution of the corporate debtor even during the CARP. Now, in fact, this was not new. Earlier, NCLTs did it using their inherent powers. Now, the regulations also facilitate such kind of direct dissolutions. And yeah. In terms of the major rulings, yes, the innovative industries, the one of the landmark rulings where the yeah, this is again a very interesting ruling. Just how Companies Act is linked here is interesting to know. In this case, actually, innovative industries is the corporate debtor. See, ideally, once the corporate debtor is admitted into insolvency, it is the RP who has to represent the corporate debtor. The directors cannot represent the corporate debtor. So, in such a case, the NCLT, sorry, in the case of Innovative Industries, the directors have continued to litigate till the Supreme Court in the name of Innovative Industries. So, one of the grounds for dismissal of this appeal was on the non-maintainability of the appeal, since the appeal is filed by the corporate debtor represented by the suspended directors, which is not possible under the law. Right? So the Supreme Court, in fact, in its order, had commented stating that this is the appeal can be dismissed merely on the ground of maintainability itself, but nevertheless, since it is a need, there is a need which has arose for establishing clarity on the IBC front. So they have taken it up and went ahead and explained a lot of things under the IBC. The role of RP, COC, etc. have been clearly explained, and even including the role in terms of the suspended directors, right, also has been touched upon in this order. So one thing is clear: is suspended directors, the directors whose powers are suspended, cannot litigate anymore on behalf of the company. Right? They cannot make take the company's name. Any litigations, appeals, etc. they do shall be only on their individual name. Yes, and then in terms of their participation in the meeting, yes, the Supreme Court has clarified that they will be entitled to all the COC documents, including even the resolution plans. It's just that, of course, they cannot vote. Right? Then, of course, the other rulings are in terms of clean slate and public law disputes in terms of the embassy property matter. And of course, even in Tata Steel, Bhushan Steel versus Venus Recruiters, again, see, since the avoidance transactions survive, the directors of such suspended companies the directors of such corporate debtors against whom the avoidance transactions have been filed, they have to continue litigating till the time these avoidance transactions are closed. So their role will still continue, because I mean, more or less in majority of the cases, it is the directors against whom such applications have been made, right? And then so that's about it. Majority of the other parts we have captured it during our other slides. Then in terms of the Companies Act compliances with RP, I think again this we have taken up already. There's nothing in addition to what we have covered here. I think this is more or less taken care of. That's about it. So if there are any questions, any further discussions to be done, we would be more than happy. I'd be more than happy to take it up. Otherwise, we can conclude the session. But just before conclusion, maybe just one last thoughts on today's session is that Companies Act, I mean, primarily IBC in its stage 1, that is CIRP, only provides for a moratorium to protect any third-party actions or to secure the company from any third-party actions, but kind of continues the company from where it is left, right? And it addresses things like powers of the board being suspended and being addressed, being taken up by the RP. Then even the LODR coming up with certain exemptions on various compliance requirements under LODR are all certain measures to facilitate the process, to ensure that the process is not boggled with unnecessary compliances, right? So therefore, in my personal view, it is important that this kind of feedback is also being taken by the ministry, and particularly under the Companies Act, there has to be some relief in terms of how insolvent companies, the companies under CIRP, what level of compliances should be mandated on them. Because like if we have seen the latest amendment to the Companies Act, which is proposed, right, the bill which is proposed has some exclusions or rather some relaxations for startup companies, or companies for the first 5 years they are trying to not to impose mandatory conditions of audit or some trying to relax a lot of compliance requirements, right? So similar effort should, in my view, should 100% be put even for insolvent companies, and it is of much more importance, so that the RBs can work with peace of mind. That's all. So that there is no time wasted on deliberating on these kind of issues. The RP should be given that peace of mind, and there has to be some clarity on how these compliances have, rather there has to be complete, relaxation on doing any of the compliances rather than leaving it open. That's just my final submissions, and then that's about it. So no questions from my side. If anyone has any thoughts, I'd be more than happy to discuss. Otherwise, we can conclude the meeting. Sorry, conclude the session. Well, I'm assuming there are no further questions. And special thanks to Sardindu sir for making it more interesting. Yesterday it was all one-sided. There was no discussion, but today it was more interactive. There's more learning, more debate. I think that's what makes the sessions more lively. Thank you so much, sir. I really feel happy that you have been following up the discussion continuously. Thank you so much, sir.
Thank you for the nice presentation. And in our discussion, if you have found me arguing,
No,
or
not,
if you have heard, I'm please
no,
excuse
not,
me,
not excuse,
pardon
sir.
me.
You
And
are
your presentation is very nice. Thank you,
Thank you,
sir.
sir.
Thank you very much, sir.
So please don't say that, sir. I'm very happy that you have been open enough to share and let me share my thoughts also. Thank you so much. And really, the session was interesting because you started raising interesting issues, practical issues, than making it more theoretical. So thank you so much for that, sir. And thanks everybody.
For your nice presentation.
Thank you, sir. Thank you, sir.
Thank you, sir. Please share this
Thank you
PPT.
very much, sir, for giving your valuable time and sharing your experience on the topic. The session was very wonderful.
Thank you, ma'am. Thank you so much.
Share the presentation of the both the sessions.
Sure, ma'am. I'll share the presentation. Yes, ma'am.
Yes, sir.
Okay, sir.
Thank you. Thank you, everyone. Thank you.